the Chief Registrar of the High Court to lead us in opening prayer. The Chief Registrar, sir. Mic to the Honorable CJ, to Honorable Chief Judge, to give us an opening remark for this session. Then from there, my Lord will now hand over to the chairman of the session for the commencement of the program. My Lord, the Honorable Chief Judge.
Second session, and that the MC has said the paper presented as Honorable Justice you ask questions, because yesterday we expected the magistrate to ask questions. Today we must ask questions. I'll make sure you ask questions. So listen attentively.
Yes. Yes. To the chair.
Ordinarily, once the CJ is around, the CJ is supposed to chair an occasion. But since you invited me to chair the occasion, I will humbly submit to that request. As you have seen from the program and the paper just served on you, Justice Muntari Show is to deliver the paper, and the paper deals with the rights of accused or defendants in criminal proceedings. This issue is very fundamental in all criminal trial because any breach or violence on the rights of an accused person could lead to nullification of any decision taken. Without much ado, on behalf of all the justices here on the high table, I hand over the microphone to
My Lord is the Honorable the Chief Judge of the State, Honorable Justice Koladiu and the remark. My Lord Judge, Honorable Justice, that's a room of my learned brothers on the high table, learned magistrates, members of the bar, other participants, distinguished ladies and gentlemen, Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. I'll quickly read through the paper, and where necessary, I will adumbrate. Before going into the paper, it is but necessary to understand some concepts as could be seen from the topic of the paper. These concepts are right, accused, and criminal procedures. Right has been defined to mean allowed. For example, if someone has a right to do something morally, legally, or officially, see Oxford Dictionary of Contemporary English. Therefore, the right of an accused person means the things or thing an accused is allowed to do or have in criminal proceedings. An accused has been defined, and this word accused is capable of accommodating singular form and plural form. That was why I wrote singular or plural. Is defined by Longman Dictionary of Contemporary English as a person or group of people who have been officially accused of crime or offense in a court of law. Now, proceedings or trial are interchangeable, meaning one and the same thing. A trial is a legal process in which a court of law examines a case to decide whether someone is guilty of a crime. Therefore, the right of an accused person in criminal proceedings refers to those things an accused is allowed to do or have legally in criminal proceedings. These rights are many, and therefore, considering the time and the nature of the audience, I shall concentrate only on those things that are fundamental to ensure fair trial of an accused person. I now examine that there is a relationship between what we call investigation and the prosecution, where the two can hardly be separated. For the purpose of this paper, I shall limit my discussion on those rights that an accused person or persons have and are guaranteed to him by the Constitution of the Federal Republic of Nigeria 1999 as amended, with reference to some few decided authorities as time may permit, while standing before a court of law for a charge or charges prepared against him under the law. Those rights are granted or donated by the Constitution to the citizens of Nigeria. Of course, an accused person is equally included, even though there is a charge hanging on his neck. Under Chapter 5 of the Constitution, tagged Fundamental Rights, certain basic rights are recognized and given to Nigerian citizens. These rights include right to life, dignity of human person, personal liberty, fair hearing, freedom of movement, freedom from discrimination, private and family life, etc. Of all these rights recognized under Chapter 4 of the Constitution, right to fair hearing may be said to be the right which squarely related to an accused facing trial. Therefore, discussion will be centered more on these rights. I start with right to dignity of human person. Section 34 sub 1A of the Constitution provides that no person shall be subjected to torture or inhuman, degrading treatment. Now, a person may ask, what has this right got to do with the person accused and before a court of law under trial? The simple answer is that regardless of allegation or allegations against an accused person, as a human being, he is still entitled to respect for the dignity of his person. And a court of law shall recognize this right and accord same to him. He should not, because of whatever allegation against him, be subjected to inhuman treatment, ridicule, etc. by the court, its staff, or the prosecution. Now, gentlemen, I need to adumbrate here. A human being has been dignified and honored by God himself, who has created him. Quran is very clear about this. It is said, وَلَقَدْ كَرَمْنَا بَنِي آدَمَ وَحَمَلْنَاهُمْ فِي الْبَرِّ وَالْبَحْرِ وَرَزَقْنَاهُم مِّنَ الطَّيِّبَاتِ وَفَضَّلْنَاهُمْ عَلَى كَثِيرٍ مِّمَّا خَلَقْنَا تَفْضِيلًا. God is telling you that he has indeed honored a human being. Not only that, he has carried human being on the air, on the sea, and gave him the best of things you can think of, and placed him before most of that which he has created. So if God himself can recognize that right, therefore we should also, as judges, recognize that right and accord the same to an accused person, even though he is standing trial before us. This right donated to the accused by the Constitution is also given, I explained that in the Quran. Now, right to personal liberty. Section 35 sub 1 of the Constitution clearly provides that every person shall be entitled to his personal liberty and no person shall be deprived of such liberty, save under the exemptions provided under subsection A, B, C, D, E, and F of that section. If you want to see the exception, you go to those subsections. The section, therefore, made a proviso that a person charged with an offense and who has been detained in lawful custody awaiting trial shall not continue to be kept in such detention for a period longer than the maximum period of imprisonment prescribed for the offense after conviction. Now, the provision provided for a person awaiting trial. The question begging for an answer is, what of an accused person undergoing trial before a court? Even though the provision does not clearly make provision for persons accused and undergoing trial directly, yet the accused person is still entitled to the right to personal liberty. A court will have to look into the nature of the allegation against the accused person. Offenses, as you all know, are classified into the punishment they obtain at the end of the trial. Where the offenses charged are simple offenses, for example, 3 years and below, the court should always give an accused standing trial the right to liberty upon such term and conditions as may be necessary to ensure his attendance to his trial. Gentlemen, this is my opinion. He should be admitted to bail upon such terms and conditions as may require his attendance to his trial. Where the punishment for the offense upon conviction is 21 years, life imprisonment, death, etc., since at the magisterial level, jurisdiction will come and determine the power to admit to bail. It is my view that even though an accused person is still entitled to bail, sitting magistrates should play safe by allowing the appropriate court with powers to grant bail in these circumstances. This is a potential danger zone. You should be very careful. where a magistrate has no power to hear and determine a matter, it follows he cannot attend to bail application under those circumstances. Section 171 of the Administration of Criminal Justice Law of Zamfara State clearly brought out the picture of the accused person under trial in a scope of right to personal liberty. This section provides, and I quote, Section 171, where a person is suspected to have committed an offense or is accused of an offense, is arrested or appears or is brought before a court of law, he shall. I underline the word because it is used, subject to the provision of this provision, be entitled to bail. It should be noted that in this section, the word shall was used by a legislature, which cannot be mandatory. It is my view that this section simply add credence to the provision of Section 35, Sum 1, which says that every person is entitled to personal liberty. Put differently, since the Constitution is the grand norm, the provision of ACGL is following the provision of the Constitution, making it to have effect mandatorily. Now, Section 172 of the Administration of Criminal Law of Zamfara State went further to specify the manner in which a court may interfere to ensure that citizens under detention are granted right to personal liberty. See Section 173, Sub 1 and 2 of the ACGL, Zamfara State. On the issue of offenses on conviction which attract detention for 21 years and above, life imprisonment, death penalty, see Section 174, Sub 1 of the law, which states that only a judge of the High Court may admit such an accused person to bail under some exceptional circumstances. For the exceptional circumstances, you should read Section 174, Sub 2 of the same law. Now I come to right to fair hearing. Section 36 of the Constitution, as amended, donated right to fair hearing to every citizen charged with criminal offense. The accused charge shall, unless the charge is withdrawn, be entitled to all the rights specified under Section 36, 4, 5, 6, 7, 8, 9, 10, 11, and 12. As examined supra, right to hearing is directly donated to an accused person charged before a court, meaning person who is undergoing a criminal trial before a court of law. We shall start by examining Section 36(4), which provides, and I quote, whenever any person is charged with a criminal offense, he shall, unless the charge is withdrawn, be entitled to a fair hearing in public within a reasonable time. Therefore, under this provision, so many rights are captured, e.g. right to fair hearing in public within a reasonable time by a court or tribunal. If we consider the last segment of the above provision, it follows that no person can be charged with an offense save before a court or tribunal constituted for that purpose. It is thus therefore clear that under the Constitution, there is no authority recognized for trial of an accused person except a court of law or tribunal. The trial must be conducted within a reasonable time. Trial within a reasonable time has been defined severally by courts. It is my view that in determining whether a trial is conducted within a reasonable time, regard must be had to the facts and circumstances of each case. I therefore call upon persons who are charged of proceedings, criminal proceedings, to try and give criminal trials the speed it requires so that the guilt or otherwise of the accused person could be determined within a reasonable time. The next is that trial should be in public. In this regard, trial in public means that the entire proceedings from arraignment to taking of evidence of witnesses, cross-examination, defense, addresses to be made by counsel involved in the prosecution of the case, and pronouncement of the judgment must all be conducted publicly. On this, see the case of Mohammed versus the state. Citation is provided. When a person is charged before a court of law and accused of having committed an offense, what is generally called arraignment, he shall be entitled to be informed promptly of the allegation against him. See Bello versus COP, Plateau State. Citation provided. Again, where the accused is informed of the allegation against him, the said allegation must be explained to him to the satisfaction of the court. The court should satisfy itself that he understands the meaning of the charge or charges against him before he is called upon to plead to the charge. And where the accused person made a plea, the plea shall be recorded as much as possible as provided by the accused person. See the case of Okoro by the state and also the case of Adamu by the state. Citation has all been provided. The practice where it is recorded by the court that charges or charge read over and explained to the accused person before he called upon to make his plea is a very good practice, and it shows that there was a valid arraignment. Note that a valid arraignment is a condition precedent, to an accused person's trial and conviction. Non-fulfillment of this condition will render the whole trial a nullity. See the case of Opera versus AG of the Federation. Where an accused persons are arraigned before a court refuses to speak or to plead to the charge, read over and explained to him, it is to be noted that should not be a burden to the court. An accused has the right to remain silent. He is, however, obliged to make statement if his silence will result in his conviction. This is the decision of the court in the case of Agogus versus the state. While I was writing this paper, the case of Gaji and the state came to my mind. It's a very notorious case which is known to all and sundry, but I couldn't lay my hands on the citation of the case. You know, Gaji was a legal practitioner who was arraigned before a court of law, and he refused to say anything. The trial went on. At the end of the day, the matter even was decided by the Supreme Court that he has the right to remain silent. It is a very important case. The accused, besides having the right to remain silent, he cannot also be compelled to give evidence at the trial. Where the accused elected not to testify, he cannot be compelled. See Section 36 of Section 11 of the Constitution of the Federal Republic of Nigeria 1919 as amended. From arraignment to the time of pronouncement of guilt, an accused person shall be presumed innocent. Thus, the accused is entitled to the right of presumption of innocence until otherwise proved. Section 36(5) of the Constitution provides that a person who is charged with a criminal offense shall be presumed innocent until he is proved guilty. In the case of Nwezi versus the state, it was held that Section 36(5) of the Constitution as amended presumes an accused person innocent until he is proved guilty. The burden of proof placed on the prosecution is not discharged until the guilt of the accused is properly established. See the case of Debiti versus the state and the case of Kalima versus the state. The burden of rebutting this presumption is on the prosecution and it does not shift. See the case of Echo versus the state. It is the right of the accused person to be given adequate time and facilities for the preparation of his defense. See Section 36 of 6B of the Constitution as amended, as well as the case of Okoye versus Commissioner of Police. An accused should also be given opportunity to defend himself in person or by a legal practitioner or practitioners of his choice. Section 36 of 6C of the Constitution. In the course of the proceedings or trial, the accused shall have the right to examine in person or by his legal practitioners the witnesses called by the prosecution before the court or tribunal. This is properly called cross-examination. Alongside the above, the accused shall also have the right to call and carry out the examination of witness to testify on his own behalf, either by himself or by legal practitioner of his own choice, on the same condition as those applying to the witnesses called by the prosecution. See Section 35, sub 6D of the Constitution. Where the accused person cannot or does not understand the language of the court, the language used that is the language used at the trial, the accused shall have the right to an interpreter who shall interpret the proceedings of the court to him. The right to an interpreter is without payment by the accused person. See Section 36 sub C sub 6E of the Constitution. A proper examination will reveal that Section 36 of the Constitution as amended donated rights on accused person to ensure that the trial conducted against him is fair. In the case of Abba versus Mondi and others, citation provided, it was held that the constitutional right to fair hearing guaranteed by Section 36(1) of the Constitution is founded upon the twin pillars of natural justice, i.e. audi alteram partem, and also nemo judex in causa sua. A proceeding conducted in breach of parties' right to fair hearing will vitiate the proceeding. See the case of Onyi, Kohile, and another versus Benue State Government. In another case of Omini versus Alabi, it was held that decisions that breaches a party's right to fair hearing as guaranteed under Section 36 of the Constitution is a nullity and is bound to be set aside. Before a round of I shall state that under Section 36(7) of the Constitution, the court is mandated to keep record of the proceedings conducted, and the accused person or any person authorized by him in that behalf shall be entitled to obtain copies of judgment in the case within 7 days of the conclusion of the case. Under this subsection, just like the others before it, it should be the word shall was employed. On this score, it is my advice that court should endeavor to adhere strictly to this provision to avoid sanction. Where a complaint is made which is successful, in respect of non-observance of the above, it will have great consequence on the court. That is, be it a magistrate or a judge. It is my view that judges and magistrates should be engaged by the authorities concerned to be skillful in processing the records of their court. In the interim, they should be sent on courses with a view to learn to process the records of their courts themselves. Relying on a typist or computer programmer will not solve the problem of production of records of court as at when due. Alternatively, the authority should consider, my Lord, the Honorable, installation of recording machines in each of the courts, which will ensure that at the end of each sitting, the record proceeding will be produced instantly. Consequently, the authority should consider capturing the issue of recording machines in the budget of the judiciary with a view to obtaining funds from the executive arm to provide for the installation of recording machines in all of our courts. It is my prayer that the fair trial issue discussed in this paper will serve as a reminder on issues that we already know, and that the targeted audience will find it useful and beneficial, thereby making the conduct of criminal trial fair and just. I thank you all for listening.
Before I go over to the discussion correspondence, let me just add one or two. It's the right of
as well as the AJA and the Evidence Act. All these pieces of legislation make ample provision that make provision for the rights of an accused person. There is also a right which has not been alluded, which I think need to. An accused person has a right not to be subjected to double jeopardy. Once an accused person has been tried by a competent court of jurisdiction, he cannot be tried again. Once he is tried again over the same fact, and that right, once he appealed, the second trial must be nullified. There is also a right provided under the Children and the Young Persons Law, even though I don't know whether Zamfara State has domesticated Child and Children Act, but the earlier law, I know, make ample provisions that a child must not be sentenced to imprisonment, but rather, once the court found him guilty, it's only to be detained at the pleasure of the governor, as well as also a person who has committed an offense during insanity period. All these people cannot be convicted and sentenced, but rather they will be detained at the governor's pleasure. With these few remarks, which I think I have not seen in the paper, I seek the permission of the Honorable CJ to hand over to the discussant for his comment.
Thank you very much for this opportunity to say one or two in relation to the topic under discussion. I seek permission of the chairman to be able to proceed over there. I can be very comfortable and look at my eyes.
You are welcome.
Thank you very much. And other separate instances together, the companies of the court. So the court is a company.
When you want to give an accused person his right, you cannot separate that. If you don't give the accused person his right, and the registrar increase his right. The court increase his right. The rest pays due process, and the court reaches the right of the accused person one way or the other. One way or the other, the court as a whole has reached his right. So I want all of you seated here, whether you're a magistrate, whether you're a registrar, whether you are a clerk or a messenger sent to go and serve process, to consider yourself for all purposes of this topic as the court, so that you watch what you do, so that you will not fall back on the judge at the end of the day. The topic has been very ably discussed by my Lord Justice Mukhtar. In the opening issue on the section 34 subsection 1 of the Constitution relating to torture, degrading treatment and all that, you were asked not to subject anybody to torture. The first thing that will occur to you is, how can the court be torturing an accused person? How can the court be degrading an accused person or treating him inhumanly? This is not a police station. This is a courtroom. But it can be done. It can be done. By the way, the judge, the registrar, the clerk, the messenger relates to the accused person, it would amount to either verbal torture or torture by conduct. If you are harsh to the accused person, especially the first day he comes to court, except those of us who are lawyers, who are regular in court, even you registrars are not regular in court except where you preside. If you appear before another court, another judge who is strange to you, you'll be moving like somebody, like a fowl, standing on one leg before you get used to that court. You cannot imagine an accused person who is coming to court for the first time and is an accused person. So when the tone of your voice, the way you gesticulate, the way you look at him means so much to him. It scares him. So you can torture him by the way you address him, by the way you gesticulate when you talk to him, by the way you look at him. Mere looking at him can be torture for such an accused person. You do not have to take a stick. You do not have to hang him like the police do. You do not have to cane him for you to torture him. What you do to him is mentally anguishing him in such a way that he is not sure he's going to get justice here. Now, when an accused person gets that impression, it follows throughout the trial. Throughout the trial. And it does not matter that it was the messenger that gave this impression to the accused person. The judge, when the accused person eventually comes before him, may be very nice and civil and polite. But the messenger who encountered the accused person in the first place, or the registrar, has already abused the mind of the accused person, and it affects the way the magistrate is disposed to the accused person. And throughout the proceedings, until that accused person is discharged, he will not believe that he can get justice in that court. So you court clerks, be careful. Messenger asked to go and serve a summons on a direct complaint, be careful. And registrars, be careful. Then of course the magistrate himself has to be extra careful. I tell you, as a magistrate, you cannot be fair when your supporting staff are not fair. So you watch out for what your supporting staffs are doing. Be interested in what they do, how they relate to clients and those who hang around you. It is mental torture when the court clerks, the registrar are seen hobnobbing with the complainants, with the police prosecutors. They're very happy with them, they relate to them. And then the accused person is kept over there, isolated, looking like a chicken in a hole where there is a python to be swallowed. So behave in such a way that you appear to be neutral, otherwise you'll be torturing the accused person by mental means. Now, I will remind you that an accused person is a normal human being. Nobody is above accusation. In recent times, Obasanjo was an accused person. charged with treason. He was in prison, he came out and became a president again. Trump in the US, after being a president of the world for 4 years, was docked as an accused person. You, court clerk, similarly can be an accused person, especially when you do those things that we sometimes do. The registrar can be an accused person, even the magistrate can be an accused person. So how would you feel if you are docked before a court and then you're now being treated as a human being simply because today you are an accused person? So always put yourself in the position of the accused person. He is a person. Section 34, subsection 1 says he should not be tortured, he should not be degraded simply because he's an accused person. Give him all his rights. I will go to the issue of personal liberty. Section 35, subsection 1 guarantees for everyone a conditional right to personal liberty. That is the right to walk about freely, go to wherever you want to go freely without restriction. But like I said, it's a conditional right, in the sense that there are situations that will warrant that right should be restricted. Now, where those rights are restricted by law, there is nothing anybody can do if an accused person's right to freedom of movement or personal liberty is restricted. But there are areas where it is allowed for him. In those areas, that is where a court is likely to either enforce those rights in the prosecution of a criminal case or breach those rights. And that is the right to bail. I quickly refer to sections section 34, section 44, subsection 1 to 3 of the ACJL, section 50, section 170 to 176 of the state law, and say that this provides the magistrate an opportunity always to give an accused person his right to personal liberty. Now, where you breach those rights is where you are careless, where the accused person has the right to be admitted to bail. You fail, refuse, or neglect to admit the accused person to bail for no just reason. Or you give bail, and then you impose such impossible conditions that it amounts to not giving bail. You ask for 10 shorties. 2 of the shorties should be permanent secretaries. 3 of them should be emirs or district heads, and so on and so forth. You think you are doing your job, but by imposing such impossible conditions, my dear, you are breaching the right of the accused person to his personal liberty where the law has allowed him to do so. The point I must make is that in recent times, or until recently, a woman comes and his son or her son or brother is an accused person before the court, and she wants to stand surety for her son. And the registrar says, no, you cannot stand surety because you're a woman. By the new dispensation, all magistrates should know and all registrars should know now that there's no demarcation, there is no differentiation between a man standing surety and a female standing surety. We're all one in that respect. So please take note, let nobody deceive you in respect of that situation. One area I'd like to emphasize in relation to the right of fair hearing is out of laziness of some sort. Sometimes an accused person is brought on the first day. An FIR is brought and the magistrate says, bring the accused persons to chambers. Mention the FIR in chambers. Whether you like it or not, it is not, your chambers is not an open court. Trials should be in public, in open courts, at all times. There is no exception. Please do very well, registrars and magistrates, to make sure that anytime you are reading an accused person or his case comes up for hearing, the registrar or the judge should ensure that the court is available for hearing and proceed to the court. Anything you read in chambers can be challenged. You must not show impatience with the accused person as magistrates. They are already scared of you. So please be patient with them. Try to understand them. They are attending court for the first time and as accused persons, so they are afraid. Some may understand what you are saying ordinarily, but because they are before you as a court, they are afraid. Try to understand them when you are going to take their plea. Don't compel them to admit their offenses. I understand how a very limited time. Thank you very much. I hope you have benefited from it.
I don't think I have much to say because my Lord Justice Charles has gone also to the paper. He has stated all the rights of the spouse of the defendant. The only thing with that, I will ask the magistrates of the courts to make sure that once an accused person is arraigned before the court, all the rights that have been enumerated in this paper, you make sure that you give that accused person the adequate chance either to defend himself in person. You also make sure that you record it where the accused person does not understand the language of the court. It must be recorded that an interpreter has been found. You make sure you set the name of that interpreter. You say, okay, Suraju has been found to interpret from the language the accused person understands the English language and vice versa. So that even if your judgment goes on appeal and the accused person or the appellant raises the issue that he was not given the right of an interpreter, your record will show, so it will be covered. His Lordship raised the issue of recording machine in the paper. As we are all aware, the judiciary is not financially independent. Even yesterday, in my keynote address, I raised that issue. In as much as I, who the judiciary wants to have all these technology, we cannot do that without getting financial assistance from the government. And all the judges are aware that the only thing we are receiving is that 10 million naira. It has not been increased. When you think of 5 high courts, each court must have working material. The government is not giving us any money to buy working material apart from that 10 million naira. And that is the money we use to buy working material, sponsor either judicial officers or magistrate or our staff for MGI conferences. So that money is not enough. But I will keep on praising for the financial independence. And I hope I believe this government has the intention of implementing the constitutional provision. He has always been saying so. I'm sure they are working on it. So I'll keep on praising. My Lord, Chairman of the session also raised the issue of rights of the child. The Child Rights Acts have not been domesticated, but what they did was to, I think, change it to right protection law. So we have that child protection law. And in that law, it is clearly stated that proceeding in respect of a child offender must be in accordance with that law. And that law has stated clearly how, when an offender is brought before a court of law, how he will be treated. And like the Lordship has slightly pointed out, you cannot see a child is convicted. It is considered as an offender. And there are so many rights, under that law that are given to the child when it comes to, trial of that child before a court of law. I believe magistrates, you all have copies of that law. You have copies of the child protection law. Okay, if you don't have, I have the copy because I requested for the copy from the Ministry of Justice. And they gave me just one copy. So I'll make sure it is photocopied and then distributed to all the magistrates so that it will be your guide. Because with that, we are supposed to have a family court under that law. And had been discussing with the Ministry of Justice because they had to put take up an initiative in, establishing that court. We, of course, will make a request, then they will forward the bill to House of Assembly, where the House of Assembly will deliberate, and then if they agree, we will now set up. But we have already sent them, we have already contacted the authority concerned, the House of Assembly, and we are making effort to see that the family court is set up in this state so that any case in respect of child offenders will go directly to that court. So I hope we will get the cooperation from the Ministry of Justice and the House of Assembly so that we set up that family court. We even had a training in Abuja where this issue of family courts was deliberated up, and so many states, even from the northern part of the country, have set up these courts, family courts, and all of Bauchi, Nasarawa, Kano, they all have these family courts. So we'll try as much as possible to see that we set up one there in the process, so that all child offenders will be identified with our court and the proper procedure under the child protection law will be followed. Thank you very much.
At this stage, any of the judges can ask questions. I want to further talk on what the commentator had spoken about, that is city chambers. I am aware there are two provisions in the Constitution that specifically talk about sitting in open court. The magistrate chambers is not an open court. So when I was a magistrate, even when I was a judge, I used to sit in chambers. And I was also earlier, and I achieved from the law school. I did discuss that with them, that the High Court or the magistrate courts are not supposed to sit in chambers. I sat in chambers, they came in. After I had the council had left, that attaché asked me, sir, were you not the one who said well, I don't know, so for that I was talking in chambers. And secondly, don't take chances. Make sure you only grant, like the commentator had said, you cannot grant bail in relation to offense of no jurisdiction to trial. I will mention names. Our two magistrates that lost their positions because of that. One here in Zamfara State, another one in former Sokoto State. They are no magistrates. All of them have retired, but they lost their positions because they granted bail in culpable homicide cases which they have no jurisdiction to trial. So please, as much as you want to assist, don't risk your job, don't risk your position because you want to grant bail. Something comes up, CJ will not spare you, I assure you. JSC will also not spare you. That is my advice. I have two questions to ask. One, my Lord, I have not had the privilege of trying an accused that is deaf, dumb, and blind. I have not had the privilege of trying an accused person who is deaf, dumb, and blind. How do you try such an accused person? This is one. Secondly,
can you have all these services together?
Dumb, and blind. How do you try such an accused person? Secondly, I also have not, in my 22 years experience as a judge, I have not had the privilege of trying an accused person who is mad and violent. What do you do with such an accused person?
What?
Assalamu alaikum.
is the second question?
I said, how do you try and accuse a person that is mad and violent?
In the case of a dumb person,
like making an accused person.
what do you call it? Blind. A blind man can still hear.
He is not a prince.
So it's just like since
He is
plans
given
are
a right
conducted,
to
about
say something. He wanted to
there's
say
no
something.
problem. It's just like somebody who.
If he would not like to say something, he can keep quiet.
Okay.
If you want to say something, he is having all the ear for saying it. But there is danger in a situation whereby an accused person has to say something,
who
but he
understands
prepared
the
to say it.
science of a dumb person.
Issue of conspiracy, common intention,
Is to
issue
look for an
of
expert, somebody who knows
the first and
science
last
and
thing in the
business.
scene of the crime.
So
All these
interpret
issues
such a
are
person
very
as not
fundamental.
just like an interpreter.
They are
who
issues
interprets
where
into the language
evidential burden
to
shifts
get an expert,
from the
somebody
prosecution
who understands the
to the
language
accused
of the
person. If he failed to say something,
communicate to them.
in that circumstances, the prosecution has done what is justified. He has discharged his legal burden
Sufficient
of
restriction
bringing the case
does not cause
to
him
a stage
to either himself
of
or
having
court.
of
Proceedings are going on.
what do you call it?
The madman
Reasonable doubt. No reasonable doubt.
appears to be mad. He's sent
Not
to the psychiatric
to the
clinic
extent of
examination.
having no
And this is
iota
going
of
to
doubt.
be mad or crazy.
There could be
His
doubt.
trial will stop until such a
There
time
will
that
be
he's
doubt.
fit for
If it
standing his
is
trial.
not reasonable, there will be doubt if it is reasonable. So if a prosecution has gone to the extent of proving his case beyond that reasonable doubt, it is better an accused person say something. Otherwise, there are so many other legal mechanisms in law that presumptions could be made, and if they are not rebutted, they stand at the position. So a accused person is not a prince. You should say something when it is important that you say.
Yes.
Another comment is, let me my Lord, in the issue of deaf, dumb, and the blind, so we interpret him, the charge against him. Or a single person.
There is not.
We get an expert. He must have people that he communicates with and live in his environment, with his society, who know how to communicate with him. Get that person and let him be the leader in the court of law.
Stop, please.
And the issue of mad and violent. I don't know whether Malone wants to say that he is both mad and violent, or that you are talking about a madman and a violent person. Okay. On the issue of that person, I suggest that he should be taken to a psychiatrist. The trial will stop. On the Saturday, when he regains his sanity, then he is brought to court. If he is still violent, after having regained his sanity, get a case, have him locked, then the proceeding continues.
Now, the magistrates, directors, you hear the
That is it.
The question has been rightly answered.